Hello everyone, my name is Vaishnavi Parate. I am a human rights activist at All India Human Rights Association, and today we are going to discuss and learn about air and space law in India. So let's start. Let's start with the introduction. Space and air law in India encompasses a wide range of legal principles, regulations, and international treaties that govern space exploration, satellite communications, aviation, and aerospace activities. Space law, on the other hand, is the body of law that governs space related activities. It is a relatively new area of law, tracing its origins only to the early part of the 20th century, but one that has witnessed astronomical growth in the past few decades. Sizable sections of this corpora of law are necessarily international, leading to them being bundled under international law. Let's turn towards to nature and scope. Humans have been always fascinated and perturbed by the upper horizons of the skies. However, throughout much of humanity's history, it neither possessed the knowledge nor the resources to reach and control these realms. Thus, the question of the existence and development of specific laws governing air and space did not arise. Presently, the scientific developments in the last 100 years have led to the dawn of the age of air and space exploration. Inevitably, a conflict has erupted over the usage of these resources, which has required new regulatory mechanisms and legislation. Let's see what is air law. The subject of air law is mainly concerned with civil aviation. It primarily exists in the form of multiple international conventions and agreements supplemented by customary rules of international law, leaving the subject in a fragmented state. Air and space law are two unmistakable spaces of law, however, are regularly befuddled as one. They share certain highlights and the meanings of some of the timing covered with one another, yet are in any case isolated with various specializations and divisions in law schools. While air law goes back a few centuries, space law is a generally insufficient field. Let's see what is space law. Modern space law is chiefly concerned with the regulation of relations among states and international organizations in the sphere of outer space, celestial bodies, and the moon. Similar to air law, the absence of a single convention has meant that the development of this branch of law has taken place largely through multiple international conventions and instruments. Nonetheless, certain principles of this branch of law, such as the utilization of outer space in bona fide manner for peaceful purposes and as a common heritage of mankind, have sufficiently crystallized to form the bedrock of the outer space regime. As stated earlier, outer space remains an international issue, and thus the United Nations, especially its Committee on the Peaceful Uses of Outer Space, has played a vital role in shaping the international conventions regulating outer space. International Civil Aviation Organization. Air law, which covers international law, is intercepted by the International Civil Aviation Organization, a specific office of the United Nations. ICAO is subsidized and coordinated by 193 part nations as signatory states to the Chicago Convention on International Civil Aviation of 1944. ICAO's fundamental goal is to keep a managerial and master organization that upholds international tact in air law and to reach new air transport strategy and standardization developments. However, it is critical to take note of the impediments of ICAO. It's anything but a worldwide controller. ICAO guidelines don't supplant enactment and guidelines in a specific country. ICAO is confined to giving a gathering to ponder between nations on sanctions, reformatory measures, and so forth on another country or nations for disregarding certain guidelines.